A very happy Wednesday to everyone. Spring is in the air. Welcome to our first quarterly advisors forum, part of the Elville webinar series. My name is Jeff Stauffer, Community Relations Director here at Elville and Associates, and I'll be your moderator for today. Today's topic is 2024 Quick Start, Hot Topics in Estate Planning and What Advisors Need to Know. Your presenter today is Elville and Associates Managing Principal and Lead Attorney, Stephen Elville. We have several new advisors on the webinar today, so I'll explain how this will work briefly. We encourage your general questions. Please note them in the questions panel on your screen, and we'll take time throughout the presentation to address them. As always, your questions always help the presentation. They add value and help others learn. So send us your questions at any time. You received the presentation slides by email from me yesterday to take notes on them if you wish. If for some reason you don't have them in front of you and you'd like to have them, they're in the section marked handouts on your screen to download at this time. For our CPAs, CFPs, and most other advisors here today, you may receive one continuing education hour for attending. So if I don't have your information already, such as an ID number or accreditation, please send that to me so I can submit the CE hours tomorrow and send out certificates as applicable. Everyone will also receive a post-webinar feedback email right after the presentation, so please take just a couple minutes to fill out this very brief survey and offer us your thoughts about today's presentation. And we have a lot going on here at the firm right now, more than we can ever begin to share. But just a few highlights. We'll be announcing the official opening of Montgomery County office in the foreseeable future here. So that's very exciting. Our biggest event of the year, our annual Client and Community Education event, is officially set for October 26th. And we had a sellout last year of 300 attendees, which was our biggest event by far ever here at Elville and Associates. We're very proud and pleased for that, and it's going to be a sellout this year again, so you want to RSVP as soon as possible when we get further details out to you. And also we'll have our first quarterly client care program event coming up, which has been snowed out 2 times, and I guarantee it's not going to snow this time. Of course, I also guarantee that the Ravens will win the Super Bowl this year, but we won't talk about that. So we look forward to this presentation today. We have a lot to cover, and I want to share a little bit about Steve and our firm, and we will get started. So you should be able to see my screen here. Elville and Associates, founded in 2010 in Columbia by Stephen Elville, and we have several different practice areas that we focus on here on a daily basis. We work with hundreds of clients on a yearly basis, and we educate thousands of people in the communities that we serve each year. We focus on estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members in 5 locations. Steve and I are coming to you live from the Columbia Gateway community right now. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at Elville and Associates, and we do that in several ways. We do that through our planning processes with our clients, and we have different programs to suit all families and individuals. We also offer many, as you know, educational webinars and workshops in the communities that we serve each year. We also have an accredited client care program, which I alluded to earlier. We're one of only 2 firms in Maryland to have a client care program accredited through the Client Care Academy in Boston. We also focus on and work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville and Associates. Just a bit about Steve. His work as an attorney for the past 23+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection, among others. A member of many different national membership and professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to offer peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve is a very seasoned speaker and presenter, if you haven't heard him present before, offering many, many webinars, workshops for businesses, their employees, conferences, and continuing education events each year. Steve is also named to the Maryland Super Lawyers list for a 9th time an 8th consecutive year in 2024. So congratulations there, Steve. He also had a feature story written about him in the National Superlawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. I'm very fortunate and privileged to be the executive director of. So when we have more time, if you'd like to learn how we work to make a musical difference in the lives of children each day, please feel free to reach out to me directly. I'd be very happy to share our story with you. Now, we have a lot to talk about what is hot in estate planning right now. And Steve knows that better than pretty much anyone out there. So I'm going to share my screen with you, Steve. Or turn the reins over to you, I should say. See that button pop up.
Very nice, Jeff. Thank you for that kind introduction.
Hey,
and good morning to everyone. Thank you. And I'm just going to get myself situated here, Jeff, and get my slideshow started. And I want to welcome everyone who is taking your time this morning out of your very busy schedules. There we go. To be with us this morning. Happy Wednesday, as Jeff said. And I want to welcome our advisors and collaborative partners. I want to welcome CPAs and also clients and potential clients and others, and all of our special guests. So it's my privilege to be with you this morning, and I want to thank Jeff for all he does to help us bring these webinars to you. And without you, we couldn't put on these webinars and provide education and professional collaboration the way that we try to do. So thank you for your commitment to learning. And I was thinking about this presentation this morning. We have so much to cover, it's almost unfair the kind of information that I'm going to need to get through this morning to give you the full overview in the time that we have. So I encourage you to have a pad of paper, a tablet, a computer out, making notes, or even the presentation itself to mark up. My hope is, as we look out the window this morning, we see the spring-like rain where I'm at, and I know those blossoms are going to come soon, those spring blossoms. I'm hoping that some topic of discussion this morning will blossom into a further discussion, because we love to do professional collaboration and learning, whether that is reviewing documents for clients or troubleshooting issues that you might be dealing with right now with current clients, or simply just learning together, having a study group that we might be able to form. Whatever that shape or form turns out to be for that collaboration, that's what we're looking for. And thank you, Jeff, for mentioning our new office at Pike and Rose, or basically going to be in that particular area in Rockville. We've had temporary locations in Montgomery County for over 20 years, but this is going to be our first permanent location in Montgomery County, and we're very excited about that. And as we get started here this morning, again, I'm going to apologize in advance about the amount of material, but we're going to get started and be finishing on time, beginning on time, and finishing on time. If you have questions, please let Jeff know. He's very, very good at moderating these webinars. And if we don't have time to discuss all your questions, we certainly can discuss those offline. So I'm just looking if there's any preliminary things that I want to make sure that I cover. And it looks like we have covered everything. So I'm going to go ahead and get started. And again, thank you for being with us. This is not legal advice in that true sense. This is higher level education and learning. So of course, anyone on this webinar, we are not in a attorney-client relationship, although we certainly could be. I think one last thing that I would like to say before we actually get started is this morning I was meeting with two young professionals in the last 24 hours, I should say, and one this morning, a young lawyer. And it was just wonderful for me to see and experience the enthusiasm of the young lawyers and their wanting to become more professional and have their professional growth and their careers ahead of them. So if I'm a little fired up this morning and I'm a little over enthusiastic, you'll understand why, because of my close proximity to those young lawyers that are so enthusiastic. And I will say that I had the privilege of interviewing several law students recently during on-campus recruiting at the University of Maryland, and I was just inspired, for whatever this may be worth this morning, I was very inspired by the young students, and I see their outlook and their aspirations to help clients and to help the world at large. So just want to say it's a very optimistic time, at least from where I sat this morning. So today we're going to cover the general outlook for 2024 and just things to keep top of mind. It's very hard to have everything top of mind, but I'm going to give you some things to try to keep top of mind. We talked about this last year, and the situation remains largely the same. We have how to plan for young clients and the moderate, wealthy, middle class, but also the burgeoning rich client, which many of you know exactly what I'm talking about. We're going to talk about the powers of attorney in Maryland and the risks in powers of attorney in 2024. Lots of things to think about. The looming changes in estate tax, we're going to be talking about that. Many of you are very aware of this, and clients should prepare now, of course. Asset protection, we're going to talk about that a little bit in 2024. Estate planning for retirement assets. The new Maryland Decanting Act, we're going to cover a little bit about that. That's a very big thing, and that's one of the most wonderful things that I could actually talk about this morning with you. Jeff and I just did a recent webinar on that. If you'd like to see my view or my overview of the new Maryland Decanting Act, please let Jeff know and he'll send that webinar to you, a link to that webinar. Special needs planning update. And then I wanted to give the advisors and CPAs on the webinar this morning a little bit of what we know comes from former officer Andre Lingham, who is an expert in elder abuse and runs his own foundation. And we know that many of you are on the front lines of seeing elder abuse in 2024, and we want to give you some of these scams and other top of mind subjects that Andre Lingham has been very nice to share with us, and we also can provide you with a webinar link to his foundation and some of the things he can bring to you so that you can be aware of elder abuse and what's happening. So the current state of estate planning in the US and Maryland is just incredible, and to be honest, it's unprecedented, the amount of tools that are available, the exemption amounts that are available for people to avoid estate tax, even though those may be temporary. The Maryland exemption remains at $5 million per person. We are concerned, at least I am, about the potential for the Maryland exemption to go down should the federal exemption go down. So that's something that's not being talked about a whole lot. It could very well happen, and we need to be aware of that, because even if it doesn't affect the federal level, doesn't affect the majority of our clients, certainly a lot of our clients are going to be affected by the Maryland exemptions if they go down. Portability, good thing, it remains intact, both in Maryland and on the federal level. Again, this potential reduction in the estate tax exemption, or the BIA, the basic exemption amount, is scheduled for January 1st, 2026. We think that's going to happen. Who knows what will really happen? But we've got a little while that we can still get clients prepared for this. All right. Maryland inheritance tax. Apologize about that typo there. The Maryland inheritance tax remains in place. However, many people are exempted. And of course, now new domestic partners that are registered can be exempted. So we have the registry of domestic partnerships, and that's something to be aware of. And if you'd like to talk about that more offline, I'm happy to do that. The annual exclusion from gift tax is $18,000 this year, if you didn't know that. Building flexibility into estate plans is not only more important than ever, but is easier than ever based on lots of tools that we have available. So this is, overall an amazing time to still be able to do estate planning, or for our existing clients to update their estate planning. So again, this bleeds into the next subject, more options than ever. Political, economic, and social change are forcing us to have to really understand flexibility. Flexibility is going to be subjective for each particular family. We have a more favorable special needs planning environment and elder care planning environment than ever before. My young lawyer that I was sitting with this morning is especially interested in the hybrid practice of elder law, which means he's going to be very interested in learning about flexibility, including the new Maryland Decanting statute. Again, if you're not following me as quickly as I'm going, I apologize. We will catch up offline or in a person-to-person meeting. The emphasis on estate planning in 2024, in my opinion, still needs to be twofold. It must be twofold. The leading edge legal technical and the mechanical practical side of it for each particular client. And then always remembering, as advisors and attorneys and CPAs, and as the collaborative team overall, the fundamental of planning, the fundamentals never change. Doesn't matter how wealthy or not a client is, individual and family self-determination and the needs for health care, financial decision-making, estate planning for loved ones, These fundamentals never change. So let's start again with the concepts of working from the ground up, the foundational estate planning. Again, these things never change. Wills, putting basic documents into place. I met with a youngish 40s couple yesterday. They may or may not do a revocable trust plan, but we need to get that basic will foundation, okay? Wills, financial powers of attorney, and advanced medical directives, covering what happens at death, what happens during life should we become incapacitated. What is arguably the most important document in all of estate planning? Financial powers of attorney. Arguably, from the attorney's point of view, the most important of all documents. Of course, many people are going to want to use revocable living trust as tools. Every month, we see revocable trusts come into our office from other offices of attorneys that never made sure the client funded their planning. And of course, that should be a collaborative effort between the client, the attorney, and their financial advisor. So we want to help clients avoid probate and have those nice revocable trust tools, but we also want to have a fully funded trust. Fiduciary selection, trustees, guardians, powers of attorney, attorneys, in fact, I should say, agents under an advanced medical directive. This never changes. It's one of the most important things that a client can go over. We have a webinar on trustee selection and fiduciary selection. If you would like to see that, we're happy to provide that to you. I've already mentioned in a redundant way, flexibility, waiving HIPAA, this is hugely important, and understanding MOLST and POLST. So again, we don't have time to get into these individual subjects, but these foundational things, if you walk away with nothing more today than the fact that in 2024, we have lots of options, lots of possibilities for flexibility, and these foundational principles never change, then you have taken away the most important things from this workshop. Again, financial powers of attorney, arguably the most important document. What we are doing in this situation is we're understanding fiduciary responsibility, okay? The client is the principal, and the person who has the power, given the power, is the agent. Understanding that fiduciary responsibility and educating that agent as to what their fiduciary responsibility is, what could be more important, while at the same time building as much flexibility as possible into that. So what does that agent have? They have a duty of care, a duty of confidentiality, competence, and diligence. They are charged to preserve and protect, to account for and record, and also use the income and principal of the principal's funds for that person's benefit. But I would also go as far as to say, use it to pay the bills and take care of the principal, also the principal's spouse, and the principal's dependents, anyone who is dependent on them. And of course, an agent under a power of attorney cannot self-deal. They have a duty of communication and information. And then of course, on the flip side, that person has limitations on their liability. As long as they're acting within the scope of their responsibility, they have a limitation on liability. So arguably in 2024, this remains truer than ever. Financial powers of attorney are incredibly important in estate planning. So the Maryland estate planning group as a whole, or bar as a whole, passed the Maryland Power of Attorney Act in 2010. And this is a very important thing to understand that most people don't know. We accept the fact that now in Maryland we have a statutory power of attorney. That statutory power of attorney is enforceable by law. Well, some of you know what it was like prior to 2010, when it was literally the Wild West in Maryland about powers of attorney, and powers of attorney were largely unregulated, in my opinion. Well, now those statutory forms, I think, give a lot of sensibility and confidence in the powers of attorney that people who live in Maryland can use and have confidence in. Now, legislative changes occur to these forms, and the most recent form was updated in October of 2023. We want to be cautious about some of the new powers that are allowed in the powers of attorney. The average person, which is, in my opinion, who the power of attorney was developed for, the average person, is now going to have access to a lot more invasive power that they can give their agent. And my worry is that some of our clients are not going to know the kind of powers that they're giving. So for example, one of the new forms, one of the powers in the new form is to give an agent the ability to create a joint account with the principal and then move assets into that account and even have access to that money as their own as a joint owner. Well, without getting into the weeds on this subject, which we could talk about for a long time, that gives an agent the ability to thwart the estate planning desires and intentions of the principal. So some of these things we just have to be very cautious about. And when you as advisors are looking at these statutory forms, I want you to be aware of this recent Maryland update, which I'm not so sure that is really in the best interest of some of our clients. And they just need to be aware it's not our decision, it's their decision about what powers they include in there. Some of the powers are optional. We just need to be aware of them. All right, let's talk about the burgeoning wealthy estate planning client. And what does that look like? Well, each one of you have a certain type of clientele that you deal with, or maybe you have a very broad clientele. I'm just going to say from the estate planning side of things, of course, for many of us who have been doing this for quite some time, we know that the average estate planning client of the past was someone between 500,000 or $1 million and 5 million, or from 3 million to 10 million. Well, the burgeoning wealthy estate in 2024 is no surprise to many of you. I'm just going to use various numbers. I don't think there's a science to this. Is somewhere between 5 and 25 million or 10 to 35 million as we look at the burgeoning estate planning client. And so this is going to depend on a lot of people's marital status, about what this looks like, single or married. It's going to depend on, of course, business that they may own or the type of assets that they have. They could have a tremendous amount of assets in IRAs or 401ks. There are going to be various estate tax ramifications and gift tax ramifications. There are going to be Maryland estate tax ramifications for these types of clients. And as I sit here with you today, I can think of 5 to 7 or 10 clients right off the top of my head that the Maryland estate tax issues are going to be very, very big for. And I know many of you are thinking the same thing. We want to keep in mind through 2024, what is the current outlook? We should be glad that we have portability, the ability of a surviving spouse to port the estate tax exemption of the deceased spouse. We want to be at least somewhat familiar with the portability rules. And life insurance trusts, as you've seen here, I put a big question mark there. I personally think that life insurance trusts continue to play a very big role. Many of you have clients that are exceedingly wealthy, above and beyond the 2 exemption amounts, 27.2 million for a married couple. You're going to need life insurance as a tool in many of these cases to deal with excess estate tax that's going to be levied among amounts above and beyond the 2 exemption amounts. Or for a single person, something above 13,610,000. But for the Maryland estate planning client as well, who may have more money than exceeding $10 million, 2 exemption amounts for a spousal couple, or 5 million for a single person, I think life insurance trusts are going to continue to play a big role. Let's talk about some of the gifting basics, and we're going to come back to life insurance. Well, obviously the annual exclusion is $18,000 per person. Between couples, they can gift split, and that means $36,000 per couple in a gift split situation. Basis, we have a transferred basis for gifts. So if there is a basis in the asset, it's not cash, then that gifted asset is basically going to have a carryover basis. Okay. So when someone makes gifts, we have to be concerned about basis, potential for income tax for capital gain after those gifted assets may be sold. There is no capital gain simply on the gifting of an asset. It's not going to trigger tax just because of the gift. There are discounting techniques that can be used. There's flexibility provisions that can be implemented for gifting. And of course, there are certain rules that relate to gifting. And of course, we have to deal with the issue of gifting during incapacity. So as we think about estate planning and tax and financial planning as a whole, the incapacity aspect and whether or not a client will foresee the need to give gifts after their incapacity through their agent, that is a big counseling issue that we deal with every day here at Elville and Associates. Portability, as I mentioned, is the ability of a surviving spouse to port the estate tax exemption, the unused exemption amount of their deceased spouse. There are tremendous advantages here for the vast majority of Americans. Now, from an estate planner's point of view, we don't want to just say that portability is for everyone, but it is for the vast majority of clients going to be the right thing to do. The first spouse to die leaves assets to the second spouse, the survivor. That survivor has the ability to port the estate tax exemption, both on the federal and state level, and that's going to be generally a very good thing. For some couples, the portability concept is not going to be the best approach, meaning leaving everything to the marital share, and that is a case-by-case basis and should not be a one-size-fits-all. There is no portability for non-citizen spouses, and as I mentioned, the Maryland estate tax issues are very favorable in the sense that the exemption is higher than it's ever been, and Maryland does have portability. Now, if there is an estate tax owed, and there is clearly going to be a liability for estate tax, then we have to take action on Maryland portability within 9 months. But on the federal level, it's 5 years. We have to indicate our desire to make the portability election sooner than later. And of course, in most cases, in my opinion, if a person is going to make a portability election, they should do it sooner than later. We are living in an age in 2024, we're planning in trust to leave assets in further trust. This could be a testamentary goal. Someone dies with a will, someone dies with a revocable trust, leaves assets in further trust, or leave outright distribution. So for each client situation, this is really going to be specifically based on that person's needs. So everyone needs to have goals. Everyone needs to have purpose in planning. Many people will express that they want to keep things simple. My response to that is, what is your definition of simple? And then sometimes when we get into the more weeds of that, now we find out that, well, they would like to keep things simple, but there are reasons why it won't work to keep things simple. So we have to have a little bit more an expansive or complex plan. So we want to define with clients what is simple in their opinion. We want to preserve and protect if that is a goal. And preserving and protecting is going to be definitional. So one person may have a point of view that, well, I want to protect by having a revocable trust. Protecting assets from probate is my idea of protection. Well, that's not what we really mean here. What we really mean is, does a person have a need to protect a beneficiary from themselves, to provide asset protection from divorce, divorcing spouses, creditors, bankruptcy? What is the need and how can we solve that need? Again, educating clients about what is available, educating children or other fiduciaries who actually receive these trusts at the death of a client. That is incredibly important, or otherwise the trust won't work the way it's supposed to. Building flexibility through all kinds of techniques, but let's talk about the trust protector for just a moment. The trust protector is a fairly new invention over the last 25 years and in Maryland law since 2014. But I strongly encourage the use of trust protectors for most client situations where there's going to be a further trust for someone. Why? Because a trust protector brings flexibility in the ability to change trustees or remove a bad or ill trustee and replace them, or to replace an interested trustee with an independent trustee to expand asset protection, or to amend a trust, or to have other special fiduciary powers if someone wants to give a trust protector that kind of power. So again, if you're not familiar with trust protectors, I think it's a very important concept for advisors to understand. There are other special fiduciaries, such as distribution advisors and investment advisors. There are cost factors. How much is this going to cost to build flexibility into a plan? So there are ways to think about this, ways to counsel. And for those of you who have clients that want you to sit in meetings, and I know many of you don't have the ability to always sit in meetings, but for those clients that allow that, you're welcome to come, as far as I'm concerned, and sit in meetings and learn about some of these concepts to whatever extent you're not familiar. Now let's continue to talk about the moderately wealthy. Again, powers of attorney should provide broad authority and not be in conflict with powers in a revocable trust. One of the things we started to see happen a few years ago and continues into 24 are test trusts. Wealthy clients that want to leave their children money in trust, but they want to leave those children in charge of a larger estate and now give those children a few months or years to learn in a test trust, a separate test trust where that child can be in charge of it. So I don't know if many of you are seeing that or not, but we are seeing that. The spousal lifetime access trust. This is a trust for the burgeoning rich client who is using their estate tax exemptions during life. So many of you are seeing this. It's still a technique that's widely used and available. Remember that a spousal lifetime access trust, which is a mouthful, is nothing more than a lifetime bypass trust. It's a non-marital trust. There is no step up in basis at the death of the grantor, but it does utilize the person's exemption. So one spouse makes a large gift into a slat, maybe the other spouse, not at the same time, maybe not even in the same jurisdiction, makes another gift to another slat for the benefit of that other spouse and the children. And in this way, one or two exemption amounts can be used. So slats can be done in Maryland. Slats can also be done in Delaware if someone, or another state, if someone wants the advantage of Delaware asset protection, which generally speaking would be greater than that in Maryland. So these trusts are counseling issues, but for your moderate to burgeoning wealthy client, this is going to be one of the ways that people can use their exemption amounts prior to potentially losing it. So we don't want our wealthy clients to lose the opportunity, and yet this is not going to be for everyone. But I think you're going to see that most wealthy clients are going to want to know about this and act on it to whatever extent they haven't already done so. There is a possibility of using upstream planning, where we're giving gifts upstream, and those people who have not used their exemption amounts, such as a grandparent, this is another strategy that is a nice strategy in theory, but we're not necessarily seeing a lot of it. There are ways of using general powers, okay? And we're not going to have time to get into all of this. Let's jump down to retirement plan assets. And we want to use good techniques in understanding how retirement plan assets can best be used for charitable planning, how clients should understand their new RMDs, how to understand the Secure Act, which we may get into a little bit longer later. All of these things are part of, really just educating the client, and it's kind of overwhelming. But once you've introduced this to the client in a collaborative way, my best prediction is your client is going to want to know more and more and more over time, and it's just something that we all have to remember. Beneficiary designations, okay, if we're talking about retirement planning for IRAs and so forth, this is still the best thing, is an outright distribution to a spouse. For charities, we want to make sure that we have perfect beneficiary designations, because charities don't pay tax on the gift from the IRA. We don't want to run IRAs through a revocable trust. This is something that can be done, and many of you are aware of the see-through trust rules, but this is something that we, in my opinion, want to generally stay away from, although sometimes it is needed. It can cause problems. We want to work with blended families. We want to understand how to hold assets from an IRA in further trust, even though there may be pros and cons to leaving an IRA to a trust. When we leave an IRA to a Q-tip trust or a marital trust, we have to understand that that trust is going to qualify as a eligible designated beneficiary for the surviving spouse, but only if that Q-tip trust is drafted properly. Otherwise, we're going to lose that exemption under the Secure Act for a spouse. And we have to understand the RMD rules. If an IRA is left to a Q-tip trust, we also need to understand how IRAs are taxed in the Q-tip trust. We need to understand the pros and cons of this as a counseling issue, okay? Let's just take a look at some of these other things down the page here, which I probably won't spend a lot of time on in the interest of time, because we're going to cover some of these briefly in another slide. Decanting. Decanting is considered a last resort, but again, due to changed circumstances, most advisors and practitioners and most clients, once they are familiar with decanting, which we're going to talk about today, may say this is really a desirable thing, even though it's kind of hard to get our minds around. Non-judicial settlement agreements for the burgeoning rich, or for any person who has an existing trust, these non-judicial settlement agreements can be a good flexibility tool, and now in Maryland with decanting can be another option with decanting to change existing trusts. So more complex trusts or even more straightforward trusts may need to be changed over time. Now, as we start to talk about these more advanced concepts, just very briefly in the interest of time, I just want you to take this slide and look at these advanced strategies. We're not going to spend much time on any of them, but I just want you to know that loans, intra-family loans, are still very, very strong tools for estate planning. Irrevocable life insurance trusts, we mentioned that. Other irrevocable trusts like SLATs, an irrevocable trust like a grantor retained annuity trust, a qualified personal residence trust, sales to trusts, charitable planning and IRAs, which we just touched on very briefly, donor advised funds, and I know there are new regulations coming down the line here on donor advised funds, elder care planning, advanced elder care planning, which is really asset protection. All of these things basically are extremely still viable as strategies in 2024. We give a webinar on irrevocable trusts and their uses, and if you want to take a look at that link, we can send it to you. Jeff, I'm going to take a drink of water, and if there's anybody that has a question, please let me know. And if not, I'm going to get into irrevocable life insurance trusts.
Nothing right now, Steve. People just love your enthusiasm.
Thank you, Jeff. All right, well, let's continue that then, as long as it lasts. Let's talk about life insurance trusts. So many of you are aware that a properly situated life insurance trust excludes the value of life insurance from the estate of the person who is the insured. And so there are first to die ILETs, life insurance trusts. There are second to die ILETs. Why am I so enthusiastic about ILETs? Well, I love the life insurance value being excluded from the estate. I love life insurance as a tool to deal with the effects of the Secure Act, and I love life insurance as a tool to deal with estate tax. So as we look at these life insurance trusts, we've long said that life insurance trusts are the Swiss Army knife of estate planning, and that probably remains true. However, I know that not all financial advisors agree with this, and there are many financial advisors that encourage their clients, I should say, to get rid of life insurance and to get rid of life insurance trusts. I just want to caution that with the looming changes in estate tax that we may be facing, old life insurance trusts that have been in place for years could turn out to be extremely valuable. So if we need to review life insurance policies, review life insurance trusts, and whether or not the best practices and fiduciary requirements have been kept up regarding crummy gifts and other things, let's take a look at those trusts. And in my opinion, let's not discourage clients from having their life insurance. Many clients strongly believe in their life insurance. Again, I'm not on the financial advisory side, but I'm just concerned about getting rid of life insurance trusts when they might be needed in the future to shield assets from being taxable in the estate of a family. Now, spousal trusts. Let's shift gears now to how to plan for spouses. Bypass trusts are basically non-marital trusts. They don't get a second step up in basis. They can provide for a spouse and children, not just a spouse. They are used, in my opinion, where someone wants extremely strong marital protection in the future, and also where someone has a very large estate. Q-tip trust or marital trust is planning with the marital share. This is giving the deceased spouse control over what happens for the survivor. The Q-tip trust, the spouse has to have all income. There cannot be any other beneficiary of the Q-tip trust other than the spouse. Disclaimer trust, leaving everything outright by way of the marital deduction, and then leaving the estate tax exemption choices, keeping in mind now that we have the umbrella of portability, so maybe a disclaimer would never be needed, but having that disclaimer in that trust or will just in case it is needed in the future. The Clayton Q-tip is considered a flexibility tool. So here we have everything at the death of the first person going to the non-marital share unless there is an election within the proper time for everything to go, or a certain portion to go to the marital share. Formula clauses are no longer needed for a lot of people. A clause that automatically separates assets into the marital and non-marital share. Powers of appointment trusts. These are trusts where assets are left in favor of a spouse, and that spouse has a general power of appointment over the assets. So all of these types of things are counseling issues in 2024. If nothing else today, I'm giving you a reminder that these things exist and that your clients have these types of things in their documents now, and they may or may not be suitable. We just need to take this case by case. Now, as I mentioned earlier, we don't always have a straight marital deduction plan for couples, not always, but for the majority of couples, that is going to be the right thing. Reasons to not include, or excuse me, reasons to possibly use, I should say, a non-marital trust plan, okay, are these here. So there's all kinds of reasons why, you know, every client situation where someone has less than 2 exemption amounts and we're not worried about estate tax, well, the simple impulse is to always plan for the marital deduction, but that's not always going to be the case. And some of these bullet points here, in the interest of time, I won't go through all of them. These bullet points represent some of the reasons to not always use a straight marital deduction. Now, portability requires the filing of estate tax returns. Most of you are aware of that. Non-citizen spouses, they create their own situation. Disclaimer planning, there's timing issues, there's acceptance of assets issues, but fortunately today, for the vast majority of people, we don't have to worry about disclaimer planning, only to include it as a potential tool because of the umbrella of portability, which looks like it's not going away anytime soon. Lastly, planning and contemplation of marriage. So there are many, many reasons to maybe have a prenuptial agreement because of spousal elective share issues and other issues. So this is something we don't want to lose sight of. Let's talk about asset protection. I know I'm going from one subject to another. I apologize. This is still a very viable strategy. The world of asset protection is constantly changing with new cases and so forth, but basically the objectives of this kind of protection, whether it's a lifetime trust, like a lifetime marital trust, a Q-tip trust, or whether it's a lifetime bypass trust, like a SLAT, or whether it is a trust that's created at the death of someone, what we are trying to accomplish is creditor protection, estate tax savings, control, building flexibility into these things. Now, many clients don't necessarily care about the perpetuity aspect, but this is what a long-term dynastical trust usually represents. Trustee responsibility, we have to be careful about how the trustee is managing that long-term trust. That's a subject in and of itself. There can be a particular trust called a purpose type trust that has concentrated assets and not necessarily diversified assets. Asset protection trusts generally are either a third party, someone is creating a trust for someone else, for example, like a SLAT, or a self-settled trust. A self-settled trust is where a person says, I'm settling this trust for myself. Maryland is not a jurisdiction where we can have a self-settled trust. And even in jurisdictions like Delaware and Nevada and Alaska, South Dakota, self-settled trusts are not necessarily going to be good choices. A pure self-settled trust is not necessarily going to be a good choice for asset protection. So there's usually a spendthrift clause. Creditors cannot attach. Okay, there are always exception creditors in most states, like alimony and child support, or Uncle Sam is an exception creditor. And of course, the discretionary trust is kind of the cake, and the frosting, I should say, is the spendthrift clause. And in most states, a creditor cannot enforce against a spendthrift provision. For those of you who are not familiar with what that is, my very simple definition would be a spendthrift provision is a provision that says, I as a beneficiary do not have the ability to alienate or assign the assets to a creditor. Therefore, my protection in the trust is secure. because I don't have the ability to give it away to a creditor. I'm not going to go through every slide here, or every bullet point, I should say. Self-settled asset jurisdictions. There are about 20 states that have these self-settled trusts or hybrid trusts or variations upon that. There are non-judicial settlement agreements that can change these kinds of trusts. So, and decanting, which we're going to talk about in just a few minutes. I think this is a very interesting bullet point at the bottom, that pre-mortem validations can be used when we see that there's going to be a real challenge that's potentially going to happen when someone dies. This is a court ruling that could be taking away that challenge in advance. So a pre-mortem validation. So we're talking about some very, very advanced estate planning concepts here. I skipped over one bullet point here about the no contest clause. Many people think that these are enforceable. Some states will strictly enforce these, but not really a lot. So we can't really rely, even though this may be changing, we can't rely on a no contest clause. Now, we talked this a little bit here about retirement planning with an estate planning. So again, Secure Act 2.0 had a minimal effect on estate planning. We know what the new age for RMDs are and how to counsel clients about that. But the IRS now recognizes a see-through trust, a conduit trust where the income from an IRA comes into a trust but automatically has to be distributed out. And we have new regulations and recognition of an accumulation trust where the RMD comes into the trust, such as a special needs trust. And the RMD is accumulated inside of that trust. So we just want to kind of really understand that with your clients accumulating assets in their retirement plans on such a grand scale, that we do really need to understand the Secure Act inside and out and how it relates to trust planning. Now, again, in the interest of time, I want to just give this to you as material. Natalie Choate, who I think is the nation's leading expert on attorney retirement planning and estate planning for clients, she's giving some advice here. There are see-through trusts. We want to look at all the beneficiaries, and to understand this, we want to understand the new tiers. There are tiers of beneficiaries that are established by Secure 2.0. The wonderful thing about this is it's providing clarity, even though getting through the weeds to understand this is a little troublesome. And if you ever want to form a study group to really get into the Secure Act, we would welcome that opportunity to come and do that with you. But actually, we're just really giving you the surface here so you can whet your appetite about how in the world do we look at these beneficiary designations and tiers of beneficiaries in relation to the Secure Act. What is the applicable payout? As many of you know, this is going to depend on these factors, which we're not going to go through in great detail. So we have retirement planning, we have the Secure Act, and we have the effect of the Secure Act on individual and couples as their estate planning. And we also have the nuances and the mechanics of how assets flow to beneficiaries in trusts and outright. And we have the mechanics of how assets are, how payouts are determined after the death of someone, depending on these factors right here. Now, I'm not, again, just in the interest of time, I'm not going to spend every bullet point here because we have to get to decanting and other issues. But I just want you to take in this slide. These are updated numbers that are on here. And I want us to remember the critical dates at the bottom. This is the biggest thing I think I would take away if I were you. That we have until the fall of the year following death to really deal with IRAs in the way they have to be dealt with. We know that beneficiaries become final on September 30th. So up till the September 30th of the year following death, we can do remedial things. We can eliminate problems that would accelerate income tax. But we have to plan to have the documents to the plan administrator by October 31st of the year following death. And we have to separate those IRAs into separate shares by December 31st of the year following death. If an IRA is designated to a revocable trust, There may be no life expectancy treatment unless it is a see-through trust, and it won't be life expectancy treatment for every single beneficiary, as if there would have been if we had done it differently. So I'm a little bit skipping past this today in the interest of getting to other material, but I want you to know this is a big issue in 2024. Let's talk about decanting. So what is decanting? Well, we're going to get into this, and we did a whole webinar on it, so I'm just going to get through these slides. Many clients don't understand this. Let's talk to them about it. Let's get them into the knowledge of what decanting is, because decanting is here. So many clients think their estate plans are permanent. And of course, in theory, the estate plan is permanent, but in reality, it is not. And what I say to clients is, do you really want a permanent estate plan? Well, yes and no, right? We want a flexible estate plan. Again, I would go back to what is the definition in the client's mind of what is simple and what isn't. What is a simple plan versus a complex plan, and what feels good to the client and what accomplishes their goal? If the client is leaving assets in further trust for a beneficiary, then generally speaking, decanting is going to be an issue, and you need to know about that. What is the client's ability to structure flexibility? Okay, well, they're either going to structure it or they're not. And if they're silent on it, then we very well may be able to decant, use non-judicial settlement agreements, as we're going to talk about, or other tools in the event that we need to change a trust. So decanting is the process of appointing property that's in trust to another trust, or amending a trust using the decanting law. So in other words, distributing property from this old trust to a new trust. All right, we're going to just keep moving here in the interest of time. This is something for a little word game for you. I'm going to give you the key. That was the legal definition of decanting. Now, what is the practical definition of decanting? Decanting is a modern tool. This is my definition now, not yours, not the legal definition. This is mine. Decanting is a modern tool developed over the past several years to bring levels of flexibility in estate planning situations that involve trusts, where certain trusts, not all, certain trusts based on their individual terms and provisions can be amended or changed from an old trust, the current trust, to a new trust under state law to achieve some kind of definite purpose, with or without court involvement. Now that is a mouthful. So I want you to take this under advisement later today or this week to read this definition again. The thing I want you to take away from the next several slides is Maryland now has stepped up to the big leagues. We now have a decanting statute, and we don't have to rely on our friends in Delaware or Virginia to be able to use decanting. Decanting can be done at common law, where you simply can change a trust, but that is the Wild West. So I would not recommend common law decanting. Other states, many other states have decanting statutes over the last 10 years. Asset protection states that I mentioned, South Dakota, Nevada, Wyoming, Alaska, they have decanting and have had for a long time. So it's no longer necessary to use self-help if we have a static trust or a trust that needs to be changed. Then came along the Maryland Trust Act in 2014, recognizing trust advisors / trust protectors. Now we have non-judicial settlement agreements. The trust can be changed by court modification and now through decanting. So we have lots of flexibility in Maryland. I am so excited about this. I didn't think I would be so excited, but I am, because we've been relying on the jurisdictions outside of Maryland for so long. Here's a quick overview of decanting. Of course, a will, if we look in the middle, a will cannot be decanted. But if we look to the left, we see, well, the client's goal was to have a trust protector for flexibility. The client understands that a future trust, not a will, a future trust under a will could have a non-judicial settlement agreement, which is basically an agreement among all the interested persons that a trust can be changed or qualified beneficiaries. There could be court involvement, or there could just be decanting with or without court involvement. Now, when this person dies with a will, they left assets on the right-hand side here. They left assets in further trust, for a spouse, child, grandchild, or even a charity. And except for many charitable gifts, if a trust provides for principal distribution in some level of discretion, that trust can be decanted, that trust under a will. Similarly, exactly like a will, a revocable trust can't necessarily be decanted, nor should it be, but when that person with a revocable trust dies, leaves assets in further trust, that trust can be decanted under certain circumstances prescribed under the law. So here's the idea. We have a new trust. This is if you look at the top left, these are assets controlled by the old trust, moved into the new trust that's been decanted. The beneficiary on the top right of the old trust remains the same. So in Maryland, beneficiaries cannot be added. In some cases, beneficiaries can be removed, but generally speaking, the beneficiaries remain the same. Tax attributes down the bottom left, the tax attributes of the old trust go to the new trust, generally speaking. Maryland law helps us with that. And on the right-hand bottom side, we have control and beneficial interest of the beneficiary may be different in the new trust. So we can't add beneficiaries, but under some circumstances, the control of a beneficiary of the old trust or the beneficial interest of an old trust beneficiary might be different in the new trust. But that old trust is completely changed or amended, but completely changed to a new trust in decanting. A good example of this is, again, we've got the client's goals. We have an existing lifetime irrevocable trust, and that trust can be decanted. So this is kind of saying the same thing. Now, some clients are going to say, well, wait a minute, I liked my old trust. I liked my old wine, when we think about decanting wine. Well, the answer is yes, you do. Do I have a choice? Well, yes, you do. A client can opt out. A client can say, I don't want decanting. Or what we do in our documents here at Elville and Associates for years is we've been recognizing decanting even before it existed in Maryland, and we've been limiting its use in documents. We've basically been saying and counseling clients, decanting's out there. Why don't we limit it to say right now, yes, you can decant my trust, but a trust for a beneficiary, but you cannot change the beneficiaries, right? So these kinds of limits can be put in documents. Generally speaking, clients probably should not opt out, but there are going to be clients that have a very, very difficult time accepting this. And there are risks, of course. There's pros and cons. The person who is the trustee who's decanting, they have duties and responsibilities. They can seek court approval, and they probably should, but they do not have to. And decanting could be very quick. It could be done within 60 days. We're just now getting started to understand this new statute. So the fiduciary has liability, and that liability can be continuing if they do not get court approval. So the advantages of decanting are that it allows the client who's leaving assets in trust for further beneficiaries to be changed due to future circumstances. There's a strong possibility of future change to anyone's estate planning based on today's laws. If we're leaving assets in further trust, that's probably a good thing, although it's going to take a while for people to deal with this. For beneficiary designated assets, there's really no applicability of decanting unless those assets are left in further trust. There is potential for changes in the laws that are going to really say, hey, we need to decant this trust because of changes in the laws. Control issues. Let's say there was a beneficiary that has a beneficial interest who's 30 years old. At 30 years old, they're supposed to get outright distribution, and the various levels of discretion in the trust allow for decanting. So the trustee not only has to be the person who's allowed to decant, but they have to have there's 3 different levels of discretion. They have to have the appropriate level of discretion in the old trust to be able to decant. So let's say that there was an issue where we needed to keep that asset in further trust for that 27-year-old who's getting ready to turn 30 in a couple of years, 2 or 3 years, and now we don't want that person to get outright distribution. Well, under certain flexibility measures that might be in the old trust or discretionary measures, that trust can be decanted, and that person's control over the assets could be limited to being in further trust. Changes in the tax laws could mean that we have to do a decanting. Changes in the beneficiary's health or public benefit purposes, there might need to be a decanting. The disadvantages, of course, are there is a trustee fiduciary risk. There could be breach of fiduciary duty levied by the beneficiaries in a legal action. There could be a dissipation of trust assets in litigation, right? Because the trustee has the authority to do this, but someone sued them. It could be that the trust needs to be removed to another state, like we always had to do. We want to decant a trust, but now it has to be moved to Virginia before we can do that. But now we don't have to do that anymore unless the Maryland statute is not broad enough, which I think it's very broad actually, but not as broad as some states. Beneficiary interest can be altered, as I just mentioned. Failure to address decanting in the documents could be a disadvantage for a client that doesn't really understand it. Or a client just simply says, I really can't get my mind around this issue of decanting. I just want to opt out of it, and I don't really want to have that in my documents. Now, we've been covering a lot of things, and our time is limited. I'm going to keep going. Many of you are aware of the Corporate Transparency Act, which became effective in January, and now we have to deal with this in a big way before 2025. And for our clients who are creating entities in 2024, okay, we have only 30 days to register. So there are certain people who are exempted, certain corporations and entities that are exempted. There was a lot of confusion. There are big penalties, $500 per day, unlimited. Many of you are concerned about this because you are dealing with large trusts or partnerships. Its reach and application is very, very broad unless we're dealing with just the simplest of situations. And I would encourage you to meet with your attorneys, meet with your CPAs, and really help get a grip on this for clients before it's too late. And I would say all of us need to have our minds and our approaches to the Corporate Transparency Act really under complete control by, I would just say, no later than June of this year. And so we're far ahead of the 2025 deadline. And advising clients is really just all we can do, and all we can do is collaborate on top of that and just make sure that we understand who is carrying the ball forward here, and that clients are aware, number one, and that they are being helped. The Special Needs Planning Update. I'm going to switch gears here. The Secure Act regulations provide a safe harbor. So we are really now in a world where special needs planning is much more defined with regard to retirement plan benefits that are coming to a special needs trust, and how that beneficiary is eligible to be exempt, one of the 5 categories of exemptions as an eligible designated beneficiary, and to make sure that the trust itself is an eligible designated beneficiary. So we won't spend a lot of time here on these things. I just want you to know that this is not changed much since last year's update, but it just remains a wonderful opportunity to understand that our special needs loved ones, people with disabilities that qualify, and chronically ill persons are exempt under the Secure Act, and this is going to be a big consideration for families in planning. One of the big issues, and I won't spend more than a minute on it, is that families that have loved ones with disabilities oftentimes have been assisted by a charity during the lifetime of their loved one with disabilities, and they want to benefit a charity. Now, since the change of the Consolidated Appropriation Act, or the EARN Act of 2022, families that are planning for loved ones with disabilities, they can leave a charity or charitable organization as the ultimate beneficiary of a special needs trust without having to suffer the disqualification of their loved one as an eligible designated beneficiary. For those of you who are numb at this point with information, I'm just going to repeat that. Prior to this act a year ago, a beneficiary of a special needs trust who was exempt, let's say, as an eligible designated beneficiary and would get special treatment for their RMDs in the special needs trust, well, if that family felt very benevolent to a charitable organization and included the charity in the special needs trust, then under the rules, that special needs beneficiary during their lifetime would be disqualified as an eligible designated beneficiary. And now that is not the case. So this is a big thing. It's a big win, and it's a big relief for families who have a strong belief in the charities that benefited them and their loved one. We now know under the Secure 2.0 that third-party supplemental needs trusts are categorized, for example, as a Type 2 applicable multi-beneficiary trust, an AMBIT, a Type 2 AMBIT. So as you work collaboratively with your financial advisory team, your legal team, your life insurance team, your CPA team, we just want to understand together that we're all getting this right for the client. A good thing to bring out on this page is IRAs that go into a first-party trust. Let's say there's a benefit, and this is nothing new, but I just wanted to make you aware of this again. Let's say you're dealing with a family, they have a disabled loved one, that disabled loved one receives an IRA of any size, but especially a mid-size or larger IRA comes to that person, doesn't matter how much, let's just say $500,000. Well, that is going to disqualify that person from their benefits. For example, it's going to disqualify them from the waiver program or SSI or means tested benefits that they receive. But now the IRS carves out an exception that that inherited IRA that that person received could be moved to a first party special needs trust, a trust that's approved by the Attorney General. And that IRA can actually not only be beneficiary designated to that trust, it can be owned by that trust. So that's something to always remember. That's a powerful technique when that happens. All right, in the interest of time, I'm going to keep going. Supported decision making, which is how to deal with self-determination basically for any person, but especially a younger person, but age doesn't matter. Maryland is now interpreting its new Supported Decision Making Act about how do we think in terms of a person who can execute powers of attorney and advance directives versus a person who needs guardianship versus a person that somewhere in the middle could have a supported decision-making agreement and maybe avoid guardianship, or maybe even have a supporter, I should say, under guardianship. So we are seeing the courts interpret this now, many times very narrowly and many times more aggressively. So this is something that's coming about in 2024. It will affect your families with elderly persons who are disabled or people who are young or of any age that have disabilities. Now, we're not going to get too much into this. This is still talking about how supplemental needs trust should be designed. This is for your information. I'm just going to say that what we really want here is flexibility, absolutely, in a special needs plan. The exemption for a qualified disability trust in 2024 is $5,050. That's up from what it was last year. And when we are dealing with an irrevocable life insurance trust, remember, we want to make sure we don't give those crummy rights to a person with disabilities. Of course, there is a third-party supplemental needs trust. This is the bread and butter of special needs planning. The first-party trust is what I just mentioned. It is a way to deal with assets that are coming into the name of a disabled person, such as from a car accident or an injury, or they've received an inheritance they're not supposed to receive. There is a hybrid sole benefit trust that we won't get into today. That is a first-party trust, and it has special treatment and is very, very rarely used, but that is available also where someone can leave assets for the benefit of a person with disabilities and not have to suffer the 5-year look-back period for making a gift. But that is not used very often, but it is available. Trustee selection remains at the very, very paramount of all planning, but especially special needs planning. I just want to say, as we start heading toward the final slides, let's look at this last part of this prior slide. Traditionally, family members would serve as, trustees of the trust for a special needs child, and in many cases do today. A person with disabilities, maybe it's a family member, but perhaps the viewpoint on this is changing across the country, that maybe professional trustees or third parties should serve in many cases as trustees of a special needs trust, and family members should serve as advocates or trust protectors. Now, traditionally, a trust protector would not be a family member. This would be an arm's length person that has no conflicts. But in special needs, we kind of turn that upside down, and we have to look at that on a case-by-case basis. So this is something that you should be aware of, and maybe you are seeing in your practice. As we start to wrap up with our last subject here, elder abuse, I want to thank everybody for hanging in there with me. Hopefully you've gotten something, some nuggets out of this, gold nuggets. Well, we have increased legislation, as you know, over the years, but we are juxtaposing that with vastly increased abuse, scams, and vulnerabilities. Law enforcement is taxed to the limit. Fiduciary selection for powers of attorney, advanced medical directives, but especially on the financial side, trustees, agents, personal representative. These key roles in fiduciary selection cannot be overstated, the importance of it. Layers of oversight in certain situations, providing for that so that it's not easy to abuse an elderly loved one. Peace of mind, building this into it, but peace of mind could mean that there's too much flexibility, or there's not enough oversight, or maybe there is more oversight than needed, and maybe that's not going to work practically. So the whole collaborative team needs to be aware that financial advisors, in my opinion, are on the front lines of seeing elder abuse. That's been my experience. I'm sure you see it all the time. You're dealing with it, and we appreciate what you're doing. Today, Officer Andre Langham, who used to be the head officer or supervisor here in Howard County for the Howard County Police Department when I was a younger lawyer, Andre is just a champion for fighting elder abuse and helping people who are experiencing elder abuse or have experienced it. He has seen it all, and he has been kind enough to let us share some of his information. And Jeff could share this just as well as I, but I'll just go right into it here in the interest of time. Andre's charity is the Center for Elder Justice and Education based in Columbia. If you haven't heard Andre speak, you advisors should just let Jeff know. And Jeff, I'm sure Andre would be glad to speak to any of the people here in attendance, our special guests, or to their groups, but also to maybe provide his presentations or however he seems that he can best help. So Andre is a champion. We have presented with him many times. Financial exploitation is growing. Let's just talk about a few of the scams. And again, I am very, very unqualified to really be talking about this. I just want to kind of give you some examples. The grandmother or family imposter scam. This is where someone receives a phone call that someone has been arrested and they need money right away. Well, this is something that, over 36 billion. Jeff, I think the numbers that we're going to show recently, coming up here, I should say, Andre may have told us that this is more than quadrupled. So it could be in the 120 to 130 billion dollar range of scams. Jeff, did you recall that or write about that?
Yeah, well, Andre said that, this is what is reported. This number is what's reported. It's probably tenfold this number, but that's what they know of as far as what's been reported.
Oh, okay. Online romance scam, creating fake profiles and so forth. Andre can tell you about what's really happening with that in case examples. Cryptocurrency scam, government impersonation scams, excuse me. Andre can elaborate on all of this. Financial powers of attorney. This is one of the things that he used to come to our office sometimes and ask us for advice about when I was a much younger lawyer about exploitation that he was seeing in the community and how agents will use a financial power of attorney to exploit. So that's just a little bit of what Andre has to share. So these are some of the statistics. The abuse is just overwhelming, especially when you see it from his point of view. So I know that each of you are seeing it and combating it the best way you can. But I just wanted to bring this to your attention and to give you the information for Andre's Center for Elder Justice and Education. So I'm going to leave this up here for just a second so that you can contact Andre Langham, who's one of the most generous persons that we've ever met to try to help others. And feel free to call him as far as I am concerned, and as far as he has allowed us to say that, yes, please call him if you have issues. And I guess nothing would be more appropriate than to start wrapping up by saying, if you have clients that have been aggrieved or abused, please let Andre know, or if you know abuse is in progress. Jeff, I believe Andre is available to use resources to try to assist. Am I right?
Andre is always available to help. He's helped so many of our clients and family members that have contacted us related to issues that they're having. So he is always open and available to talk, and has helped so many people that we know. And he's always available for presentations for your office or your clients. That is what he specializes in, is educating. He always says educate one and then educate another one. So that's what it's all about, spreading awareness.
Thank you, Jeff. And so we wanted to bring that to you today because in 2024, this remains one of the big issues, and hopefully you've benefited from that. So what should advisors do now? And we always try to give clients or advisors or our collaborative partners a path forward. So thank you for your patience. I hope you've gotten something out of this today. Schedule a meeting with us and let's talk about what we can do to collectively help and advise our clients at a very high level. Discuss how we can best collaborate. Clients have goals, they have concerns, they're fearful, and why shouldn't they be? Look at the news. Let's meet, let's advise, let's collaborate, and let's help people form an advisory team if they don't have one. We are here to review any existing documents for your clients. Generally speaking, we do not charge to review documents, and many times we just need to review existing documents, point out what is missing or what could be updated, asset alignment, what should be fixed, how to get those corporate interests to flow through the estate plan properly. I mentioned study groups. If any of you would like to have a study group to raise your practice level, we would value creating a study group, and one of our attorneys or even myself can participate in that study group and help everyone learn and collaborate. We want to discuss the latest techniques in asset preservation and having assets under management for the financial advisory firm. This sometimes includes trustee selection. Many of you have broker-dealer relationships where there are independent trustee relationships. You will find, if you haven't already done this, that your clients, many of them are going to want to keep assets under management with you as long as you're in the financial advisory business or your succession plan to your succeeding advisors, and keep assets under management, not only for business purposes and success for your own self, but to help the client accomplish their long-term goals where they are leaving assets in further trust. And then we want to just always discuss the techniques we are learning and using to accelerate our own growth in our practice and yours. All right, Jeff, well, that was a lot, and I didn't leave a whole lot of time for contemplation or examples. I just really needed to get through that, and I hope everyone understands there's a lot going on in planning in 2024, and I'm just going to put our last slide up. We appreciate you. Thank you for your support and for spending your time on a Wednesday morning. We hope to meet with you. We hope to be a resource to you.
Well, thanks, Steve.
Yeah, I'll turn it over to you.
Thank you, Steve. Always a lot of great information. We could spend hours doing this presentation, and there's always time for contemplation, right? So we do have a couple questions, and then we'll go ahead and end. Our good friend Frank, Steve at the church, says, any thoughts on inherited Roth IRAs if it's passed on to multiple children and a nonprofit?
Well, thank you very much, Frank, and hello, by the way. I hope things are going well. Could you email me that offline? And the reason I ask is I'm not really sure whether you're asking about a charitable contribution that's going to go to a charitable remainder trust, where there's going to be some lifetime beneficiaries, or whether, and then a charitable remainder, or what you're really saying by that question. So please email that offline, and I promise I will follow up with you.
Okay. And last question for now is from our friend Janelle. She says, if one is planning for inheritance of an IRA for a disabled person, isn't a third-party designation much better option than use of first-party trust by the disabled beneficiary?
Yes, Janelle, hello, and thank you. Yes, and I know from your long experience as an attorney, you would understand exactly what that question means. So yes, we never want to leave, in my opinion, an IRA to a first-party trust where we have the opportunity to leave it to a third-party trust. And Janelle's question is very well taken, because my example of when an inherited IRA is left to someone with a disability and has to be transferred ownership to a first party trust. That is not preferable. We want that IRA to go to a third party, bread and butter supplemental needs trust where there's no payback to the state of Maryland. Janelle, thank you very much for that because my example could have been misinterpreted. So thank you very much for that.
Thank you. So we'll go ahead and wrap up here. We have lots of great presentations coming up, including Maryland Able next week, Estate Planning Essentials with Renee Boyd, and our Wellness Series on March 19th. We're also presenting at the Brain Injury Association of Maryland Conference on the 22nd. We've been there for, I think, 10 straight years. So if you're going to be there, please stop by and see us. I look forward to seeing you there, hopefully. And again, I've got a lot of information to send over to you in a follow-up message, which I'll be sure to do no later than tomorrow morning. I'll try to get to it this afternoon. And we'd love to meet you, whether you're an advisor here or a curious client that came on board today. So thank you for being part of our first quarter advisor forum, and we look forward to seeing you again soon as part of the Elville webinar series. Have a great day.